YouTube. This video stems from a viewer's question I received on my last video. Can the police enter my home and arrest me without a warrant? Please, if you have any questions you would like answered in a future video, jump down in the comments below, and you never know, your question may be spotlighted in a future video. Also, if you like this video and would like to see more videos like this one, please subscribe to our channel. Now let's dive right into today's question. Can the police enter my home and arrest me without a warrant? To shine a light on this question, we will be looking at a case decided by the 11th Circuit Court of Appeals, Shepard v. Budnick. This provides a thorough explanation of constitutional law governing warrantless in-home arrest. Shepard's facts are as follows. Shepard alleges that around 9:30 p.m. on August 5, 2002, he and his wife were eating dinner in their home when Officer George Davis and Officer Jason Budnick of the City of Hallandale Beach Police Department knocked on their front door. Shepard arose from the dining room table, went to the door, and asked, "Who's there?" After Officer Davis responded, Hallandale Beach Police Department, Shepard opened the door, where he faced Officer Davis, who was standing alone just outside Shepard's residence at Shepard's front door. Shepard asked, "May I help you?" and Officer Davis replied, "We are here to arrest you. You are Dwayne Shepard, correct?" Shepard alleges that when he responded, "Yes, I am Dwayne Shepard," Officer Budnick appeared and joined Officer Davis in the doorway. Shepard then asked the officers, "Do you have a warrant?" Neither officer answered. Instead, they entered through the front door, grabbed Shepard by the arm, and pushed him into his living room onto his sofa, which is about 6 feet from the front door. The officers arrested him on the sofa. Subsequently, Shepard was charged with lewd and lascivious conduct with a child and contributing to the delinquency of a minor. Shepard pled no contest to the charges and was given probation. Nevertheless, he broke his probation and received a 15-year term. Officer Davis and Budnick were named in his lawsuit. He claimed that they violated his Fourth Amendment rights when they entered his home without a warrant or authorized and arrested him after modifying his complaint. Officer Budnick claimed that he was entitled to qualified immunity since he was arrested in the doorway, commonly known as a threshold arrest, and that the law was not firmly established in this area. Officer Budnick was granted qualified immunity from action because the district court determined that the law regulating doorway arrests was not firmly established. When a government employee, such as a police officer, is sued for a constitutional violation committed while performing a discretionary act, the court must first determine whether the officer infringed on the plaintiff's constitutional rights. If the cop did not break the law, the court will grant him summary judgment, which means the case against him will be dismissed. If the court finds the officer did breach the plaintiff's constitutional right, the court must then determine whether the statute was clearly established at the time of the constitutional violation occurred. The officer is entitled to qualified immunity from action if the law was not clearly established. If the court finds that the law was clearly established, the officer loses qualified immunity and the case moves to a jury trial. Shepard appealed to the 11th Circuit Court of Appeals after the trial court granted Officer Budnick qualified immunity. On appeal, he claimed that the arrest was not made at the doorway or threshold, but rather around 6 feet into his residence. Shepard then argued that qualified immunity was not appropriate because the officer did not dispute the location of the arrest, 6 feet inside the home. He did not consent to the entry, and that there was no exigent circumstances, and that the law prohibiting warrantless in-home arrests was clearly established. The 11th Circuit began by reviewing judicial precedent pertaining to the question of whether Officer Budnick's entry into Shepard's home without his permission, shoving him 6 feet inside, and detaining him violated the Fourth Amendment. The Court of Appeals first looked at Payton v. New York, judgment of the United States Supreme Court. The Supreme Court stated in Payton that it is a basic principle of the Fourth Amendment law that search and seizures inside the home without a warrant are presumptively unreasonable. The Court of Appeals did highlight, however, that a warrantless arrest within a residence may be justified under the Fourth Amendment if it falls under one of the exemptions to the warrant requirement. The court went on to say that one of the well-defined exemptions to the warrant requirement is consent. The court, however, citing precedent from the 11th Circuit, noted, For the consent exception to the warrant requirement to apply, the consent must be voluntary, or, as we have stated, the product of an essentially free and unconstrained choice. The Court of Appeals next considered whether Shepard gave his implied agreement to the officer's entry into his residence when he opened the door and indicated that he was Dwayne Shepard. The Court of Appeals stated that implied consent existed. Whatever relevance the implied consent doctrine may have in other contexts, it is inappropriate to sanction entry into the home based upon inferred consent. Moreover, we have determined that a defendant's act of opening his door, stepping back, and placing his hands behind his head did not amount to implied consent to be arrested. The court then applied the aforementioned standards to Shepard's facts. According to the 11th Circuit, as a result, the Court of Appeals determined that the officer had infringed on Shepard's constitutional rights. The 11th Circuit then looked to see if the law governing warrantless in-home arrest in factually comparable situations was clearly established at the time of the arrest. Again, if the law isn't clear, the officer is entitled to qualified immunity from the complaint. When the contours of the right are sufficiently obvious, such that a reasonable officer would realize that what he is doing violates that right, a constitutional right is considered firmly established. The United States v. Santana case was the first to be examined by the Court of Appeals. The Supreme Court of the United States ruled in Santana, a suspect may not defeat an arrest which has been set in motion in a public place and therefore proper under Watson, involving a warrantless arrest in a restaurant by the expedient of escaping to a private place. The Court of Appeals also mentioned the Supreme Court's decision in Payton v. New York. In the absence of consent or exigent circumstances, the warrantless search or seizure of a suspect in his home violates the Fourth Amendment. That a person could be arrested at the threshold of his residence if he so consented. Finally, in the United States v. Edmondson, the Court of Appeals looked at its own precedent. When an FBI agent told Edmondson to open his door and step back, he obligated and then put his hands on his head. The government claimed he agreed to his detention. The 11th Circuit ruled in Edmondson, a suspect does not consent to being arrested within his residence when his consent to the entry into his residence is prompted by a show of official authority. The Court of Appeals in Shepard then applied the rules above to the facts of the case. They claimed the officers in the case ignored Shepard's questions and entered through the front door, grabbed Shepard's arm, and pushed him 6 feet into his living room onto the sofa where they arrested him. In essence, the officers not only failed to acquire a warrant or obtain consent before going to Shepard's house, but also forced their entry into his home. Shepard's question about the warrant, if anything, showed a lack of implied consent. The Court of Appeals also stated that Shepard's arrest was not a threshold or doorway arrest like the one in Bird's because he was pushed 6 feet back into his home and arrested. The 11th Circuit then held after applying the facts of Shepard's case to the rules outlined above. Considering the above precedents, on August 5, 2002, the pre-existing case law from the Supreme Court, this circuit, and the Supreme Court of Florida clearly establishes that 1. In the absence of consent or exigent circumstances, a warrantless arrest made within a suspect's home is unreasonable under the Fourth Amendment, and 2. A person does not consent to being pushed back into his home and arrested in his living room by merely opening the front door in response to a knock, an announcement by law enforcement officers, especially when that person immediately asks if the officers have a warrant. Applying this clear and established law to the facts of this case, a reasonable officer would have had fair and clear warning that he could not go to a suspect's house, knock on his front door, wait for him to answer, and without hearing anything else besides, "May I help you? I am Dwayne Shepard," or "Do you have a warrant?" grab the suspect's arms, push him 6 feet into his living room, and arrest him on his couch, all without a warrant of any kind. At this juncture, there is nothing in Shepard's amended complaint that places him in the threshold or inside the doorway. Simply put, Shepard's arrest was not a threshold arrest. Accordingly, because the Officer Budnick violated Shepard's clearly established Fourth Amendment rights by arresting Shepard in his home without a warrant, consent, or exigent circumstances, we find that he is not entitled to qualified immunity on Shepard's unlawful arrest claim. As a result, the Court of Appeals ruled that the District Court erred in providing qualified immunity to the police because the law was clearly established, and thus reversing its ruling and stripped Officer Budnick of his qualified immunity. Well, I hope you enjoyed today's video, and if you would like to see more content like this one, please subscribe to our channel. Also, if you have any questions you would like answered in a future video, jump down in the comments below, and you never know, your question might be spotlighted in a future video. Thank you for watching, YouTube, and until next time, stay safe out there.